Let me try. Junsu Kupio Savonilla something?
Almost. En yhtään keksi, mitä tässä yhteydessä kannattaisi puhua, mutta voimme yrittää jotain selittää.
What did you say?
I have no idea what to say, but I can try to say something.
Welcome to another episode of the FSR Policy Briefcase with me, Leonardo, Meeus, and
me, Menegatti.
And also our guest, who is this week, Kaisa Huhta. Now, Kaisa is a professor in our school, Florence School of Regulation, and also at the University of Eastern Finland. You might wonder, why has the university this name? Well, turns out it's a merger of three universities in three different locations. So you can't pick one location's name. So you say, well, it's more or less Eastern Finland. Let's call the university Eastern Finland, which I think is a big improvement because I would have more difficulty pronouncing the names of the three universities. Let me try. Junsu Kupio Savonilla something?
Almost.
As you can see, Kaisa is also very diplomatic. What else to say about Kaisa? Well, she is also an academic superstar. How do you become an academic superstar these days? In the past, like me, I was just trying to publish. You publish in the right journals and you hope that sort of gives you some credibility. But these days, you apply for an ERC grant and you have one, right?
I do.
And it has a really cool name. It's Coming of Age of the New Legal Discipline, General Doctrine on Energy Law. Nice. But that's not what we're here today. Well, maybe there's some connection with it. We're here today to talk about independence of regulators. And I think Emma will kick it off with the first question.
Yes, thank you. And before going into the briefcase in detail, I wanted to discuss a bit the role of these independent regulators. So there are different types of tasks and responsibilities set out in the EU law, right? Some are more borne by the government, some by the regulators, and some are maybe more in between, and maybe it's up to member states to choose. For example, in network planning, sometimes the regulator has more of an advisory role. So could you first help us understand a bit what's the role of these independent regulators? When do they take independent decisions or not? And yeah, what's the interest of having these independent decisions?
Yeah, thanks. And first of all, thanks for having me here. The independent regulators have a long history. The need for this kind of strong institutional setup was first recognized by the Commission's sector inquiry in 2007, where they found that member states were still intervening politically with the functioning of the energy markets, and strong independent institutions were suggested as one means to address this kind of political interference in the energy markets. And since then, all the internal electricity and natural gas directives have gradually increased the powers and tasks assigned to national energy regulators. In principle, the division of tasks is simple. So the government is still responsible for making the political decisions on deciding the energy mix and figuring out the general structure of the member states' energy sector. And then the technical implementation, overseeing and monitoring compliance with these rules, it is a task for the independent regulators. If you look at the internal market directives for electricity and gas, you see that there are 30, 40, maybe even more independent tasks that have been given to the regulators. They are different types of tasks. Some of them are more abstract and loose, and others are more kind of detailed tasks, and everything in between. And so, in principle, it's a simple division between the government has the political power and the regulator has the technical powers to kind of oversee compliance with the legislation. But in practice, real life is much more complicated, and there's a lot of grey area in between. And I think the recent case law from the Court of Justice kind of demonstrates that there's a lot of room for interpretation in those rules, and what falls within the tasks and powers of the regulators, and what's then left for the governments to execute.
Yeah, because tasks, I guess, can be something like giving advice, writing a report, or take a decision, but then even take a decision can be somewhat constrained or not, right?
Exactly. Exactly. And also, the fact that something is technical does not mean that it's not also political. And sometimes there is this misunderstanding that if something has numbers in it and it's very technical and detailed, it can't include any political decision making. But obviously that's not the case.
Yeah. Before we dive into some of those cases you already hinted to, can you also say something about the institutional setup of regulators? Because as you said, there is more and more legislation pointing to some authority, an energy regulator, but that energy regulator is not necessarily a standalone entity, right? In some countries it can be a multi-utility regulator, sometimes even combined with a competition authority. Does legislation say something about that as well, or is that really a choice for member states?
There is a lot of room for interpretation again in member states. So they have a broad margin of discretion in how they decide to implement this institutional setup. There are some clear rules that need to be complied with, but then there is flexibility. And in Finland, for example, some of the tasks that other member states have decided to give to the energy regulator are with the National Consumer and Competition Authority. So there is some flexibility. And the rationale for giving member states that flexibility is that they are able to fit the energy regulators within their own institutional traditions and institutional setups. So no need to reinvent the wheel, but kind of try and figure out how these obligations could fit into their national setups.
Yeah. Okay, great. We dive into the brief. Is that okay, Emma?
Yeah, okay. We can go.
So first I have to admit that before reading the brief, I thought always of these court cases on the independence of regulators to be something like regulator does something, government is unhappy and tries to intervene, and then there is a court case because the regulator sort of tries to maintain independence. And right. I think some of the cases you refer to are a bit of that type, exactly. Like the German case. But there is also a very recent a Slovenian case. I don't know if it's a court case, but at least there was a situation where the regulator had decided to allocate the network costs in a different way instead of more volumetric tariffs. They went to peak tariffs, and of course some people pay less than, some others more. The idea was to make it more cost reflective, but that doesn't necessarily make everyone happy. So that's the classic type of cases. But then the more recent Finnish case that you also discussed seems to be of a completely different nature, where you actually have a situation where it's the companies that go to court to complain about the independence of the regulator. Because if I understood correctly, in Finland you have a very long regulatory period of 8 years in which normally there is no intervention by the regulator. So you set a benchmark, and if the company outperforms the benchmark, they can keep the money, right? But sometimes that leads to a situation where the perception is that they maybe earn more money than they should, but then you cannot necessarily intervene as a regulator. So then there were a few exceptions in Finnish law to allow an intervention anyway, and one was the change of the law, and then the government did that, enabled sort of the regulator to intervene, but then the companies were of course not happy. Yes. So this is completely a different type of case. No, it's not about how to allocate costs to Finnish customers, but more how much money these companies get. Did I understand that more or less?
Exactly, that's exactly how it went. So the Finnish energy regulator made a decision in the middle of the monitoring period, changing the tariff methodologies. And when I say tariff methodologies, I mean the amount of profit the network operators can recover for their activities, and what they can include in their activities to be recovered then from the customers. So basically, how much are they being paid? And the energy regulator changed that methodology in a way that did not make the network operators happy. And that's a decision by a public institution that can be appealed. And so I think nearly, if not all, Finnish network operators appealed the decision to the Finnish Market Court, which is a specialized court that deals with appeals from the Finnish national energy regulator, also called Energiavirasto. And during that procedure, in that market court, there was a question that popped up about the interpretation of the independence requirements set out in EU law. And so the market court decided to refer to this question to the European Court of Justice, asking them about the correct and uniform application of that requirement of EU law. And so that was a judgment that the court delivered in March this year. And now the case is back in the market court, who will then decide based on the advice, well, not advice, but based on the interpretation of EU law from the European Court of Justice, will then decide how to interpret the national setting. So it wasn't a case of the Finnish energy regulator being worried about its own independence. They did not, to my understanding, they did not consider their independence breached. In fact, they were adamant that they had adopted the decision independently. But the network operators, being very unhappy with the new methodologies, then used this independence requirement as means to potentially challenge the new methodologies.
Very interesting. And so where are we in that challenge? I mean, on which side is it going to go? Do we already know, or do we have an indication? Because you said it's back in the Finnish court.
It's back in the court. Maybe I should disclose it here that I'm also a part-time expert member of the Finnish Market Court. So I know my colleagues are the ones making the decision. I'm not personally involved in this particular case, but I know that it is pending and that they are expecting a decision soon-ish.
Yeah, super interesting. And based on these court cases that we just discussed, and the ones that you dive a bit more in detail in the brief, which, by the way, I encourage our listeners to check out, you highlight several ways forward, right? So where do we stand now as regards this independence of regulators? And what can the EU and maybe member states do next to reinforce or to enable this regulators' independence?
Well, in the policy brief, I focused on two cases particularly that dealt with the adoption of tariff methodologies. So when I talk about the ways forward regarding independence, I'm looking at it from the point of view of tariff methodologies, which is not by any means the only task for national regulators, but it is one of the most influential ones because it has a direct impact on how much or how little consumers or network users pay for their electricity or gas. And because of that, it's also one of the more politically sensitive tasks that the national regulator has. And maybe because of that political sensitivity, there is more motivation for governments to intervene with the setting of tariff methodologies, as kind of demonstrated by the number of cases we've seen in national and EU courts. And if we look at that setup and that legislative design, I think there are two ways forward. One takes place on the EU level and one takes place on the national level. And I think on the national level, it would be super important that member states were to really carefully implement the requirements that we already have in the internal market directives. So there is this provision that requires that all parties that are affected by the regulator's decisions have the right to appeal those decisions. And I think many of the challenges that we faced in these court cases are because there haven't been balanced procedural rights for both network operators and the consumers. So for example, if only the network operators have the right to appeal, it's kind of it's easier for them to challenge a system that is not working for them. But if consumers and network users do not have any of those rights, then there's a risk that this creates an imbalance in the regulatory system. So there is already provisions. There are already provisions in the existing legislative framework, but member states need to be careful in that they implement these provisions carefully and in a balanced way. And then there is the EU level measures that can be taken. Now, I know that this is a hot topic in Europe at the moment because the clean industrial deals suggest that there might be some level of harmonization in tariff, in network tariffs. And I know this is a suggestion that has received a fair amount of criticism. I'm not in favor of like harmonization of network tariffs, but I do believe that when it comes to tariff methodologies, the substantive criteria set out in EU law, in the electricity regulation particularly, and the corresponding instrument for gas, they are really abstract. They don't provide very much kind of concrete guidance for the regulators, but they leave them with a lot of political decision-making powers, not just technical, but they leave a lot of room for interpretation for them in determining what is meant by cost reflectivity or what is meant by proportionality in tariff methodologies, and maybe in clarifying some of these very abstract substantive criteria, it would be possible to provide a bit more kind of clarity to how member states, how the division of tasks between the government and the member states regulators ought to look like.
Mm-hmm. Yeah, because that could reduce the number of court cases.
Yeah. Yeah.
And it's happening a little bit with guidance documents and things like that.
That's true, but national courts aren't very keen to use EU-level soft law instruments. It's not a tradition in many member states. The court cases help. So they do provide guidance for member states' courts in how they interpret this independence requirement and how they see concepts like cost reflectivity. This can be a task also for the European Court of Justice, but it could also be a task for the EU legislator.
Okay, thank you. Very clear. So thank you, Kaisa. I don't know if, Leonardo, you have other
I just have one more question. So in my search on Eastern Europe, Eastern Finnish...
Is it about pronunciation?
No. This time it's about, are you a member of the ice swimming club?
Actually, I am. I am a member of an ice swimming club in Joensuu.
I'm not sure if I will visit you then. There are a few other clubs there that I'm less afraid of. You have your own forest. Is that true? Sort of close to one of the campuses, a forest. There is forest everywhere, probably.
Yeah,
basically.
I mean, it's Finland. Forest. it is in a forest.
So maybe you will visit for the forest, but keep the ice.
Keep your mind open. Yeah. It was only -42 last winter.
I'll let you close.
Yeah, well, thank you, Kaisa, and thank you, Leo. I really enjoy learning a bit more about these independent, sometimes not so independent regulators. And I would say now I can picture them a bit more, sometimes under pressure by governments, sometimes overruled, and sometimes even teaming up. That's something new for me, teaming up with governments. And it was super useful to hear more about how the EU law and also these court cases help define in more details what we mean by independent regulators. So thanks to you. I'm also very hyped about these court cases. And I look forward to hearing news about, because they're still ongoing, right? So let's see over the coming years. And so before we wrap up, quick shout out to all our new subscribers on YouTube and to everyone that follows us on Spotify, SoundCloud, Apple Podcasts, etc. And a big thanks also to all those that like, comment, and share our episodes. We really appreciate the energy, so please keep it going. And with that said, we'll see you in the next episode.